Is joining us right now on LinkedIn. So we'll give everyone just a few seconds here to get their LinkedIns turned on before we get started. There we go. All right, I can see some of you already know the drill out there, already getting your introductions in. I appreciate that. Thank you everyone for joining us today. I am Tricia Meyer, the Executive Director of the Performance Marketing Association and a well-known FTC rule junkie. So this is kind of like Christmas, Hanukkah, New Year's, like all wrapped up for me to actually have somebody from the FTC on here talking to us today. I'm going to be talking about some of the recent rules and how they impact specifically affiliate marketing, influencer marketing. So while I'm having our panelists introduce themselves, I also would like those of you who are watching us on LinkedIn, if you could quickly drop in a quick introduction, but also let us know a little bit about what you do. That way we can kind of tailor some of our Q&A to the things that you're looking for. So are you brand, are you agency, are you publisher, influencer, network, where are you coming from? This webinar is going to be slightly different than the ones that we normally do because we will be starting with our expert. He'll be giving a presentation for a little bit, going through a lot of the information on the rules to start with. We've also been collecting questions from PMA members from the PMA Compliance Council over the last month in preparation for this. So once he finishes his presentation, then Gayla and I have a list of questions that we've been dying to ask. And then at that point, we will be opening it up to bring in any questions that those of you are asking who are on LinkedIn. So you can drop in questions as we go, but once we get to that point where we've gotten through the presentation and then also through our Q&A, I'll start bringing your questions over to the panelists. So without any further ado, let's get started. First, I want to thank IntegraShield for sponsoring us today. Without sponsorships like IntegraShield, we would not be able to do all the great work that we're doing in the PMA. So with that, I will start with Gayla from IntegraShield.
Hello, I am going to try to match your energy, Tricia, because that was amazing. That was the most organized, thorough introduction ever. And I'm Gayla Huber. I am the president over at IntegraShield, and thank you for giving us a platform for this, Tricia. I'm part of the Compliance Council at PMA. And when this first came up and we were all talking about it, trying to get the news out and to all of the membership and then beyond membership. And then Michael, of course, was so generous with his time to agree to do this. So I will pass it over to Michael.
Good afternoon, everyone. My name is Michael Ostheimer. I'm an attorney in the Federal Trade Commission's Division of Advertising Practices. I'm happy to be here with you today. And even though we mostly won't be talking about disclosures, there's one disclosure that they make me make, which is what I say does not represent the views of the FTC or any individual commissioner. They're my views. So look forward to—
That's the little attorney asterisk there that we got to get in.
And hopefully it's not in fine print.
Terrific. Well, I'm going to actually have Michael, he's got a presentation put together for us for this first 10 or 15 minutes. So I'm going to let him share his screen. I do see somebody in our last webinar had asked us about us adding captions to our LinkedIn Lives, and it looks like those are working. So I'm so excited, and thank you for the person on the last webinar that suggested that, because it looks like they are going well. So from here, I'm going to let Michael take it away.
Sure. Well, today we're going to be talking about the FTC's new rule regarding consumer reviews and testimonials. Let me give you a little bit of background. Many consumers rely on consumer reviews and testimonials and ads to decide what to buy or who to hire, and many companies rely on them to attract customers. But some businesses abuse consumers' trust by engaging in fraudulent review and testimonial practices. And we don't think that the market will correct this problem on its own. The FTC has challenged illegal practices regarding reviews and testimonials for many decades, bringing numerous law enforcement actions. We've also issued and updated business guidance on these topics, including the Endorsement Guides, but it hasn't been enough. Almost 2 years ago, the Commission began a rulemaking intended to address truly egregious and inarguably deceptive or unfair practices involving consumer reviews and testimonials, while not burdening honest businesses. The rulemaking process provided multiple opportunities for public participation. We heard from a broad range of perspectives from consumers, small businesses, advocacy organizations, trade associations, review platform operators, researchers, and others with an interest in the area. The public comments received were very useful and caused the Commission to make numerous clarifications and adjustments to its previous proposal. We believe that the rule will increase deterrence, allow the Commission to allow the commission to secure redress more quickly and efficiently, and enable the commission to seek civil penalties against knowing violators. Under the FTC Act, to be liable for civil penalties for rule violation, the violator would need to have actual knowledge of the violation or knowledge fairly implied on the basis of objective circumstances. The final rule will become effective on October 21st, which is 20 days from today. Like other commission regulations, there's no private right of action. As originally intended, the final rule remains narrowly focused on finding egregious and clearly deceptive or unfair practices involving reviews and testimonials. Any deceptive or unfair practice involving reviews or testimonials, which the rule does not cover, is still subject to the FTC Act. Some of those other practices are addressed in the endorsement guides. And I flipped the slide a little too early, but this is the first substantive provision of the rule, section 465.2. It addresses fake and false consumer reviews and consumer and celebrity testimonials. Let me explain what we mean by consumer reviews and by consumer and celebrity testimonials. By consumer review, we mean a consumer's evaluation or a purported consumer's evaluation of a product, service, or business that is submitted to and published on a website or platform dedicated in whole or in part to receiving and displaying such evaluations. So consumer reviews could appear on a site dedicated to consumer reviews, like Yelp, or they could appear in the review section of a retailer website, like on a product page. They could appear on Google. There's lots of places they could appear, but it has to be a dedicated section of a site for displaying reviews. A testimonial, on the other hand, is an advertising message. It's an advertising message that consumers are likely to believe reflects opinions, beliefs, or experiences of a consumer or celebrity who has purchased, used, or otherwise had experience with a product, service, or business. Testimonials can appear in traditional ads, like radio and television ads. They can appear on a company website or in internet ads. They can appear in social media. Most consumer reviews are not consumer testimonials, and most consumer testimonials are not consumer reviews. But if a business pays for or gives incentives for consumer reviews or of its business or its products or services, then those incentivized reviews will also be considered consumer testimonials under the rule. When I said that section 465.2 addresses fake and false consumer reviews and testimonials, I meant ones that misrepresent that they're by someone who exists, who doesn't, that misrepresent that they're by someone who had experience with the business or its products, or that misrepresent the experience of the person giving the review or the testimonial. Section 465.2 prohibits businesses from writing, creating, or selling fake or false consumer reviews, consumer testimonials, or celebrity testimonials. That could apply to a business that writes and sells fake consumer reviews to others, or that writes fake consumer reviews for its own products. It could apply to a business that makes up a celebrity endorsement of its product. It could also apply to a paid influencer who lies about having used a product or service or about their experience with it. The provision also prohibits businesses from disseminating or causing the dissemination of consumer or celebrity testimonials that they know or should know are false. By should have known, we mean that a business should not ignore red flags that a testimonial it disseminates or causes to be disseminated is likely to be fake or false, and the business should act accordingly if such a flag is present. For example, if someone gives a testimonial about a product and then asks for the product, a business should question whether the testimonial has ever used the product. Similarly, if a business knows that someone gives a testimonial, who gives a testimonial is using a competing product, it should inquire as to whether the testimonial for its own product is truthful. A business shouldn't provide the text for a testimonial without a reasonable basis to conclude, based on inquiry or otherwise, that the text is truthful about the testimonial's experience. Finally, the provision also prohibits businesses from buying consumer reviews that they know or should know are fake or false, and prohibits them from procuring consumer reviews from certain company insiders for posting on third-party sites, when the business knows or should know that they are fake or false. The rule does not impose a general duty for businesses to investigate whether each consumer review of its products is fake or false. However, it's possible that a business may possess clear indications that purchased reviews are likely to be fake or false, in which case a failure to investigate further may trigger liability under the should have known standard. For example, let's say the business hires a third party to generate reviews by providing free samples of its products to consumers. Whether the business should investigate the resulting reviews will depend on whether it's on notice that they're likely fake or false. The business would likely be on such notice, for example, if the reviews appeared so quickly after purchase that it's doubtful they reflect real experiences with their product. If an unusually large number of views appear in a very short period of time, or if they refer to the wrong product. Section 465.2 has an exception for generalized solicitations to past customers to write or post reviews or testimonials. Sending out an email to everybody who purchases a product. We'd really love if you'd write a review. Here's a link. There's nothing wrong with that, and we wouldn't expect to hold a company liable for any reviews or result that are fake or false. That exception applies even if the solicitation offers an incentive. We'll give you something off the next purchase for $5 for. The provision also has an exception for when a business is simply hosting reviews on its website. So if all a company's doing is hosting reviews, they're not responsible for checking whether any of these reviews are fake or false. It's only if they themselves wrote or bought or procured the fake or false reviews from their employees. A business may take all of the consumer reviews submitted to its website and share them with a third-party review platform, which then publishes the reviews together with reviews from other sources. The business won't be liable under the rule if it turns out that some of those reviews it shared were fake or false, unless they were fake or false reviews that the business purchased or that it procured from company insiders. Section 465.4 of the rule prohibits businesses from providing compensation or other incentives contingent on the writing of consumer reviews expressing a particular sentiment, either positive or negative. Negative would be if you're purchasing reviews of a competitor. Violations include situations in which such a contingency is expressed or implied. So, for example, while it prohibits offering $25 for a 5-star review, it also prohibits offering $25 for a review, quote, telling everyone how much you love our product, end quote. The provision does not prohibit giving incentives for reviews, as long as there isn't a requirement that the reviews have to express a particular sentiment. That said, failing to disclose incentives could be a violation of the FTC Act. Section 465.5 of the rule addresses reviews and testimonials by certain company insiders. The provision prohibits a company's officers and managers from writing reviews or testimonials about the business or its products or services without clearly disclosing their relationship. Businesses are also prohibited from disseminating testimonials by officers, managers, employees, or agents without clear disclosures if the business knew or should have known of the relationship. The Commission intended for the term agents in this rule to apply only to agents such as representatives of advertising agencies, public relations firms, and review management firms. The Commission does not expect that a business will ask every potential testimonialist if they're an insider. There may be red flags, however, that could cause a business to realize that a prospective testimonialist is likely an insider, such as a testimonial featuring an image of the person standing in front of the company's headquarters. Or if the business routinely asks prospective testimonials how they became interested in the business or its products, it should not avoid looking at answers that might indicate a material relationship. The provision also contains a prohibition that comes into play when an officer or manager solicits reviews from their immediate relatives or from employees or agents of the business, and when officers and managers ask employees or agents to seek reviews from their relatives. For these various solicitations, the rule is violated only if the resulting review appears without clear disclosures and the officers and managers, 1, encourage prospective reviewers to not make disclosures, 2, did not instruct that prospective reviewers make disclosures, or 3, knew or should have known that such a review appeared without a disclosure and failed to take remedial steps. The Commission does not expect an officer or manager, even one who solicited reviews, to scour every review of the business for possible insider reviews appearing without a disclosure. There may be red flags, however, that should cause officers and managers to inquire further. An example that is at least applicable to smaller companies is when an officer or manager asks employees to obtain reviews from relatives and later spots a review without a disclosure by someone who the officer or manager recognizes as having the same last name as an employee. Another example is an employee sending a soliciting officer or manager a link to the resulting review, in which case the officer or manager should take the time to see if that review has a disclosure. Let me clarify that all of these various insider prohibitions in section 465.5 hinge on the undisclosed relationship being material to consumers. It has to be one that they would care about, that would matter to them. There are exemptions to this insider provision for mere review hosting and for generalized solicitations to past customers. The rule contains a definition of what clear and conspicuous means in the context of the required material connection disclosure. Among other things, the disclosure must be easily noticeable and easily understandable by ordinary consumers. It also has to be unavoidable. Section 465.6 of the rule addresses things like fake expert review sites and fake seal programs. It prohibits businesses from misrepresenting that websites or entities they control or operate are providing independent reviews or opinions about a category of a business's products or services that includes their own business, product, or service. It does not apply to consumer reviews. We're talking expert reviews or otherwise business type expert reviews. Section 465.7 of the rule deals with the problem of businesses using unfair tactics to get negative reviews taken down. It prohibits businesses from using unfounded or groundless legal threats, physical threats, intimidation, or certain public false accusations to prevent the posting of or cause the removal of all or part of a consumer review. The use of public false accusations is a violation when the accusation is made with knowledge that is false or with reckless disregard as to its truth or falsity. Legal threats are unfounded or groundless if they're unwarranted by existing law or based on allegations that have no evidentiary support. So the rule doesn't prohibit a business from threatening legal action when there's a legitimate basis for doing so. The rule doesn't prohibit a company from contacting customers who post negative reviews to resolve the disputed reported issues. It also does not prohibit them from simply asking satisfied customers to update their reviews. It doesn't prohibit offering incentives to consumers for taking down their negative reviews, but offering such incentives could be an unfair practice in violation of the FTC Act, as we discussed in our endorsement guides. Section 465.7b of the rule addresses a different type of review suppression when a company suppresses negative reviews on its own website. It prohibits a business from misrepresenting that the reviews on a portion of its website dedicated to reviewing and displaying such reviews represent most or all of the reviews submitted. For example, a company could set its review management program to only post 4 or 5-star reviews, and that would be a violation. By suppressing reviews, we mean reviews that are not displayable. That's different from how reviews may be organized. The rule doesn't address organizing reviews, but organizing reviews in a way that makes it difficult for consumers to know about or find negative reviews could be an unfair or deceptive practice or act in violation of the FTC Act. Again, the provision only applies to reviews displayed in a portion of a business's website or platform dedicated in whole or in part to receiving and displaying consumer reviews. So it doesn't apply to the selective use of a particularly positive review in marketing materials. Such selective use of non-representative consumer reviews in marketing could be a deceptive violation of the FTC Act. There are numerous possible legitimate reasons for suppressing reviews. The rule gives examples of some of them. like if the content is defamatory, harassing, abusive, obscene, vulgar, or sexually explicit. The requirement is that the business applies this policy, whatever it is, to all reviews equally, whether they are positive or negative. The final substantive provision of the rule, 465.8, addresses the misuse of fake indicators of social media influence. Indicators of social media influence are things like followers, connections, subscribers, views, plays, likes, saves, shares, reposts, and comments. A fake indicator means one generated by a bot, a faked account, a hijacked account, or one that otherwise does not reflect real individuals or entities' activities or opinions. The rule provision bars anyone from buying or procuring such fake indicators when the purchaser knew or should have known that the indicators were fake and the purchaser used them to misrepresent their influence or importance for commercial purpose. It also bars anyone from selling or distributing fake indicators of social media influence that they knew or should have known to be fake and that can be used by individuals or businesses to misrepresent their influence or importance for a commercial purpose. On our website, we have a business blog discussing the rule, and at this moment, we're working on a guidance document, which is in question and answer format, and I hope it should be available shortly. And that's it. I welcome your questions. I'm going to stop screen sharing.
Hey, Michael, just real quick, you guys are going to have a guidance document. Are you also going to have sort of something specifically for the small business community, or will it be the same document?
It'll be the same document. Right now, as I said, there's a blog, which is maybe a couple pages long, but we'll have a question and answer document for everyone.
Okay.
All right, ready for the questions?
Dude.
So I have to say, like, normally when we go to the PMA members and we say that we're doing a webinar and we say, if you have any questions that you want us to precede, let us know and we'll do that. And we typically get maybe 3 or 4. We have 13 questions to start with today.
Okay.
And that's the narrowed down version.
Right, and this is kind of narrowing it down. So, all right, Gayla, you want to take off with the first one?
Yeah, you mentioned towards the beginning of your presentation that essentially this has always been the rule, right? Fake is not okay. And that it wasn't enough. So you guys had to move forward with this to get this under control. What are or were the most common things that you saw that people should really be paying attention to? Can you give us like a couple examples?
Well, I mean, we weren't necessarily creating the rule based on the most common issues involving reviews and testimonials. We were trying to address the ones that we thought were most clear-cut violations and most egregious, such as fake or false reviews or testimonials, review suppression, incentivized reviews that had to be positive or negative. The various issues that are covered in the rule are the practices that we thought were clear-cut violations. I mean, what is giving incentives that aren't disclosed more common? It might be a more common practice, but it's not as clear-cut a violation.
Just kind of going on with that, how does the FTC know when it is fake? I mean, I know how we know, but we're often working directly with the brands because they want to make sure that's not happening. How do you know?
We have many possible sources for opening an investigation. Can be in response to complaints from consumers, from complaints from competitors. We get tips from company insiders. We get tips from, sometimes we've gotten tips from industry watch, people who are consumer groups or others that are watching the industry. And it's also possible we get tips from platforms sometimes too.
Okay. So the next question is, what were the key changes compared to any previous guidelines in this area?
Well, we've had the endorsement guides for many years. We updated them, I think, last year, and we'd also updated them 10 years previously to that. The guides cover many, many issues, And the rule focuses on a subset of those issues, and it makes those practices inconsistent with the rule violations of the law. Guides are just guides. They're interpretations of the law by the commission. They don't have the force of law. If somebody does something inconsistent with the guide, we would have to go to court and prove that the practice violates Section 5 of the FTC Act. Here, we just have to prove it's inconsistent with, it violates the rule, and then it's a violation of the law. Also, a violation of the rule allows us to get consumer redress, and it also allows us for knowing violations to get civil penalties.
So I guess that is actually, what do those enforcement and penalties look like for violations?
Well, for the penalties can be as much as, I don't know the exact number, but over $51,000 per violation, 51,000 so many dollars. And that can add up quickly. So, I mean, that's not necessarily the penalty, it's up to that. And it's up to it's not a fine that we issue. It's a civil penalty imposed by a judge. And we would have to convince the judge of the appropriate penalty. And it would be up to the judge to determine what would be the appropriate penalty. But it can add up very quickly. And consumer redress would be giving money back to consumers based on the injury that results from the violated practices.
And those penalties per instance, so that could be an influencer that does something multiple times, those would each be an instance, or a brand that's working with multiple influencers, those are each an instance?
Yeah, those could all be instances. I mean, it would be up to the court to determine how they want to view it. But I mean, it could be that each post is a violation. It could be that each review is a violation. I would think it would be, but that's it really depends. I mean, on what the judge thinks, but I would think it would be.
So since it does add up pretty quickly, the rule coming out, you said it was October 21st. Do people need to take action on anything that was previously out there prior to October 21st?
Well, if a company has a fake testimonial on the website and they don't take it down, it's a violation if it's still up there after October 21st.
What if it's on like a consumer review website that they don't own, or Yelp or something like that?
I would think that would be difficult for us to argue was a violation if the practice occurred before the rule went into effect and the company didn't have the ability to take it down. I would not consider that violating the rule. I mean, it would violate Section 5. We could still prosecute as a violation of Section 5, but I would have a hard time seeing how something on a third-party platform that happened prior to the implementation effective date of the rule was a violation.
Okay. Yeah, and I guess I use bad examples. We usually have more trouble with maybe like a Google, or if an account gets locked or something on Facebook. So those are hard to get down. Okay.
Well, I mean, if somebody has something deceptive on their Facebook page, I would think that, and they continue to have it there, I would think that would be arguably, I would think that would be a violation.
And so for publishers, bloggers, affiliates who have a lot of content that they've built up on their sites over years, they should be going back through that content in anticipation of this going into effect?
Well, I mean, hopefully a company doesn't have fake or false testimonials on their website. And by the way, when I say false testimonials, we mean ones that misrepresent the person's experience with the product. But if they have fake or false testimonials, yeah, then they should go back and review all that old content that's still available on the website. But I mean, hopefully your members don't have fake or false testimonials on their website.
Yeah, I was thinking,
or
like,
in their TV ads.
Yeah, I hate to call people out, but I was watching another Kardashian this weekend thinking about our upcoming webinar, and they were promoting a product, and I was like, huh, I feel like this might just based, I'm not gonna say what it was, I'm gonna get her in trouble, but based on that particular product, I'm like, there's no way they tried that. So yeah, okay.
I mean, if there's an influencer who says they use their product and they didn't, that is a violation.
Yep.
If they're paid, if it's a paid influencer, an influencer who is paid to promote a product, they say they used it and they didn't, then it's a violation.
Okay.
Mhm.
Trisha, I think you've got a few more than me if you want to knock.
Or if they
some
say they use the
off.
product to lose 20 pounds and they only lost 2 pounds, that would be a violation too.
All right.
You must have seen the same commercial.
No.
So you kind of touched on it, but the difference between rules and guidelines. So the endorsement guides were guides over disclosure. This is a rule. Can you explain that a little bit more, what the difference is between those two?
Well, the endorsement guides aren't just about disclosures, they're about all sorts of issues. I mean, the endorsement guides, for instance, cover issues like typicality. That if somebody shows an endorsement, a testimonial on their ad, it's likely to convey that this is a typical experience of consumers who use the product. And so one shouldn't use outliers in one's marketing. And if one does use an atypical testimonial, one should disclose the expected results. Clearly and conspicuously disclose the expected results. That's an issue that's come up in commission cases over many years. It's included in our guides, but it's not an issue that we included in the rule. As I said, the rule, we've tried to focus on really clear-cut violations that we think are always deceptive, always egregious, cut black and white, very clear. And if someone engaged in a practice, let's say that's covered in our endorsement guides, and they engage in that practice in a way contrary to our guidance, we could bring a case saying that you violated Section 5 of the FTC Act. But it's not just a violation of the rule. The rule, we can get civil penalties for violations, for knowing violations. We can't get that if someone engages in a violation of the FTC Act, just that's covered, let's say, in endorsement guides, if they just do that. Also, we can get redress currently for violations of a rule. For violations of the FTC Act, we would have to bring a follow-up action. After administrative case, you'd have to bring a follow-up action alleging that the conduct was fraudulent or dishonest in order to get consumer redress.
Okay. And so going back to kind of what you were saying towards the beginning of that, we work with some companies that are dipping their toe into the affiliate space that have not previously. That I think that's a really good point. With this rule, that does not sort of take away the idea that they can make weight loss claims that just because that person had something that was completely not typical, those can't be sort of the standard claims that are out there. So there's definitely, we want the truth, but we also can't make outrageous claims that aren't typical for everyone.
So we had an audience question come in that I do want to toss out there, and that is, how are software partners or affiliate networks exposed to any of these compliance measures? So, for those who are watching, so we have these brands over here, and we have the publishers or the influencers over here, and these kind of software technology companies in the middle that are branching the brands and the influencer, the publishers. Is there liability for those software companies in the middle that are just bridging the two?
I'm sorry, what is the software company doing? And when you say bridging them?
So they're the tracking platform for the contracts between the brands and the publishers. So they're providing the mechanism for the contracts to be signed. They're providing the actual tracking for commissions to be paid. So they're not actually a part of any of the content generation or making the contracts or anything like that. They're just facilitating from a technological standpoint. They're facilitating the relationship between the brands and the publishers.
I don't see how that would be covered by the rule. I mean, the various provisions of the rule mostly apply to companies that are taking acts and practices with respect to their own products, services, or business. I mean, if that company was buying fake reviews for its services, it would apply to them. If they were buying fake followers on LinkedIn for LinkedIn, it would apply to them. But if some influencer engaged in if an influencer lied about having used a product, they're not the one lying. It applies to businesses, either a business that hires an influencer or hires a fake review, or hires somebody to write fake reviews. It doesn't apply to a third party like that. I mean, yeah.
Trisha, though, so
And I'm talking
some,
about, just to be clear, I'm talking about the rule. I'm not talking about Section 5 of the FTC Act. I'm talking about the rule.
The new rule. Okay.
so Trisha, some companies might use a platform, not necessarily for the tracking, but they might offer a marketing tool platform that generates content that would suggest that the company is okay with that content. And I know recently the AI company that got in trouble for generating reviews, that could probably be dicey if you're not keeping an eye on what's being generated, if you're allowing access to those marketing tools.
Yeah. So Michael, is there any element of control in that? So if, assuming it's just nothing but a straight platform, just technology, they're not facilitating, all they're doing is facilitating the transactions as opposed to them maybe getting involved in the transactions, them helping the brands to recruit the influencers and things like that. If they're starting to have any kind of control like that, does that change things?
Well, under the rule, either way, I don't see a third party being liable under the rule, except for the types of scenarios I mentioned. I mean, if they're engaging in review suppression, if they're but they're not. I mean, they're not responsible for other people's practices under the rule. As far as under Section 5 of the FTC Act, yes, if intermediaries can be liable if they're depending on what their involvement is. I mean, ad agencies can be liable if for problematic practices. That doesn't mean that they would be liable simply for being a conduit for contracts. But I'm not going to say that. I mean, we believe that intermediaries can be liable for certain deceptive, violative practices. Like, I mean, for example, if we brought a case involving disclosures by influencers where we brought a case against the intermediary who was hiring the influencers and directing the influencers.
Right. That makes sense. All right, Gayla.
Is there a specific or an example of a disclosure that you could share with us? Is there one that you've seen that you're like, this is a good disclosure?
For what purpose?
For a testimonial.
For what purpose?
I know there's so many. That's a hard question.
Well, I mean, if you're talking about for the only disclosure involved in the rule is company insiders. The rule does not apply to, let's say, disclosure by an influencer. It doesn't apply to other disclosures of typicality. There's all sorts of disclosures that may be appropriate involving reviews and testimonials. The rule doesn't apply to those. It applies to insiders who are giving reviews or testimonials. So if somebody's giving a testimonial about their company's product in a television ad, I mean, they could say, I love my company's product. It does this. That might be good enough. They don't have to necessarily say #employee.
Okay.
But I mean, it really depends. I mean, they need to communicate clearly that they have an employment or familiar relationship to the company. My uncle's restaurant is really, actually not my uncle. The rule doesn't even apply to uncles and aunts. My father's, it has to be an immediate family member to be precise. My father's company makes a really great widget, whatever it is, would be what they could say, would be one way of saying it.
Okay.
But the rule only applies to immediate family members, not uncles and aunts and cousins.
Is the FTC more concerned with the brands who are paying for sponsored content reviews, or the people that are publishing those reviews and the content, or are you looking at it equally?
When you say publishing reviews, I don't know really what you mean by publishing reviews.
So if someone's out there writing a review and being paid for it by the brand, but perhaps they didn't actually even try the product. They wrote a review just so that they could make money off of the brand. So they didn't actually try the product, but they said that they did. Is the FTC more concerned with the brand because they are getting the benefit of that positive review and that they paid for? Or are they more concerned with the person who wrote that fake review?
We're concerned about both. And I mean, in the past, we have brought we've brought our cases against the entity, the business buying fake reviews. But if we can identify and locate someone who's in the business of writing fake reviews who we can reach, it seems like it would be a good target to also bring.
So we had a question come in that I popped into the chat. If you want to be able to see it as well, I'll read it, but it's kind of long.
I have not been paying attention to the chat.
Oh, that's all right. No, that's fine. I'm just putting it in here because it's a little bit long. So if you want to read along, I'm going to read it out loud, but just in case you want to read along with it as well. What is your experience with consumer review sites where they offer to solicit feedback or reviews via phone calls to your list of customers? We're told that they are considered, quote, more valuable since it's collected by a human, but does that introduce bias? So consumer review sites where they're offering for a price to solicit the feedback and reviews via phone calls to your list. Does that make a difference?
None, unless the solicitation says that the review must be positive or suggests that the review must be positive. And again, tell us we'll give you some sort of reward or money for telling us how much you love our product. That would be, if it's the solicitation both gives an incentive and requires that the review be positive or negative, expressly or implicitly, that could be a violation of the rule. Other than that, it's not covered by the rule. It's a different question whether this practice could be deceptive in violation of the FTC Act. I mean, if they are truly calling everyone and giving everyone the same opportunity to provide a review and all reviews are published, yeah, then there's nothing wrong with it. And I personally don't know whether consumers are more likely to respond to a phone solicitation. I'm not an expert on consumer response to solicitations. I mean, it seems like it might be likely, but as long as there's no way that is treating positive reviews more favorably than negative reviews, then it seems like it should be fine.
So this one I just popped into the chat. This is a lot more in Gayla's wheelhouse than in mine. So if you want to take asking this one.
Oh no, they're asking the FTC and FCC question.
I don't know what TCPA interaction is. I have no idea.
That's more FCC, but they said bonus. The intended definition of the seller. Who's asking this? I'm like, I want to know. Hit me up after, whoever's asking that. That's more of an FCC thing on the one-to-one consent rule for TCPA that starts in January. But whoever asked that, just hit me up on LinkedIn after and we can talk about it.
All right, Rocky, hit Gayla up on LinkedIn afterwards and she'll be able to take that
Rocky?
question for you.
Hey, Rocky.
And that is the thing that I think for a lot of people, FTC, FCC understanding.
It's all the same.
that there's like interplay with the way we look at these things, because there's, sometimes overlap. If I do something, it's an FCC violation because of this, and it's an FTC violation because of that. So I think for a lot of consumers and even those of us in the industry, it can get a little bit confusing sometimes which one and how those play together. But kind of speaking of our industry, and very selfishly, we, the PMA, we're an industry association of affiliate marketers. So we work with brands, we work with the influencers, the publishers, the B2B, the compliance companies, all of those kinds of things. And as the only industry association nonprofit in the US, what are the kinds of things that we as an industry association can be doing to kind of help our industry to be more compliant, to help us get ahead of some of these rules, and just overall, so that we as an industry look like, we really are trying to be the good guys. We're trying to do the right thing.
I mean, educate your members. Spread our education materials, create your own and spread them. Tell people about the rule. I mean, hopefully your members are not violating the law all along, and they won't in the future, but they should know about the rule, and you should educate
some of them
them.
are. Some of them definitely are. And every time I see something, it frustrates me, because there are people in our industry that are not following these. They're not following the guides. They're not following the new rule. And I don't think it's just because it's not actually in effect yet. I think it's because they don't understand, or they are just willfully non-compliant, because they figure the FTC is not going to come after me. I'm too small. How are they going to catch me anyway? Like, I think there's a lot of that still. And so,
Well, to that extent, then there's probably not much that you as an industry trade association can do about those members. I mean, you can tell them that, yes, we do go after smaller players, and we're looking for all sorts of cases to bring involving rule violations. It's something we're looking for. Can I promise them that they will get caught? No, I can't. But just because somebody's small or because they've gotten away with in the past doesn't mean they'll continue to get away with it.
Yeah, based on what you were saying earlier about how you get your tips and do your investigations, I don't think anyone, even small businesses, should be overlooking this.
Kayla, do you have any more of our pre-scheduled questions?
Well, we kind of had for you to give some people some advice, but I feel like you've kind of done that already. But is there anything that you haven't mentioned yet that you would give as advice to folks, as just sort of, I love the part about the timing. I actually had never thought about that, where if a business doesn't know if things are fake, but they can look at some different factors like timing of the reviews to see if that's the case. Have you ever come across any other tips that you could give businesses to say, oh, this might indicate that it could be fake?
By the way, just to be clear, that guidance about the fake was when the business actually purchases or incentivizes the reviews. We're not talking about, just to be clear, we're not saying a business has to be on the lookout for just fake reviews coming into their website.
It could be a third party. From the business perspective, they could be unaware that a third party that they've hired might be doing that. So I think looking at timing is still really good for them.
Yeah, if a business hires a third party and to basically purchase reviews, procure, incentivize reviews, there are things that then they should be looking to see whether the things like the timing is just unbelievable, or if the reviews are about other products, things like that.
Another one of the questions that came in, how do the rules vary by industry? For example, retailers versus financial brands, and are the regulations either more lenient or strict by these types of verticals?
It does not vary by industry. It does not. It's the same for everyone. I mean, there are some entities for which we do not have jurisdiction. We don't have jurisdiction over banks. We don't have jurisdiction over the business of insurance. But as long as we have jurisdiction, the rules are the same for everyone.
So we had another audience question come in that I've put into the chat. how do you think the new rules will affect review sites where the sole purpose of those sites is to funnel traffic to advertisers? So for example, a casino review site, and those sites, they're paying for premium placement. So the casino is paying to be listed first on that site. Will a simple paid for placement note suffice? It would be very difficult to prove that these reviews aren't legitimate.
I'm sorry, these are review sites that have reviews that are supposedly consumer reviews or supposedly expert reviews.
I guess it could be either one, because I think some of these publisher sites are acting as a consumer who has maybe visited all of these casinos in the past.
Okay.
Some of them are saying, I am an expert in reviewing casinos because I travel all the time.
Mm-hmm. Yeah, I mean, either of those. Okay, let me step back. If let's say a casino hypothetically created its own casino review website, and it controlled that site, and it rated its own casino 10 on a scale of 1 to 10, and gave everybody else 3 or 4 or 5 stars or whatever it is. That would be a violation of the rule, because the company is creating a website that it sounds like it's giving independent reviews, expert reviews of casinos, but in fact it controls it and it's favoring its own. That would be a violation of the rule. Now, if a third party created a review website for casinos, and there's nothing necessarily deceptively wrong with that, but let's say it gave better reviews to companies that paid it more money. That seems like it would be a deceptive practice. It would violate Section 5 of the FTC Act, in my opinion, but it would not violate the rule.
And so if it violates Section 5 of the FTC Act, so that is still something that you could bring an
We
action.
could definitely bring a case, and we could sue them, we could get injunctions, and depending what other bad practices they engaged in, I mean, we might be able to get money at some point, if not right away. But it wouldn't be a violation of this particular rule that we've been discussing today.
Okay.
And if a third party set up a site that had consumer reviews, I'm sorry, I wasn't sure what the question was about consumer reviews, whether the reviews would be fake. I'm sorry, I wasn't sure. I didn't really understand.
Yeah, so I think what they're getting at is that, it's not the casino that set up the site. It is some type of publisher doing reviews of things, but the publisher is being paid for them by the casino, but they might be being paid by 4 casinos. They're listing reviews for 10 of them. They're getting paid for 4, so those 4 are listed at the top.
Yeah, that could be a deceptive practice, but it would not be a violation of the rule.
What if they wrote a review of the casino, but they'd never actually visited the casino? If they said, this is my favorite casino, they have great strong drinks when you sit at the table, so I love them, but they didn't actually ever go to that casino. Does that then put them in danger of both, because they're being compensated to put them first, but they're also reviewing the product that they've never actually touched?
It would be for the review website that says if it's giving a consumer, if it's giving actually, I'd have to think about that. I really would have to think about that one. I mean,
It's more an endorsement, right, than a consumer review at that point?
Well, that's what I was thinking, whether it's a testimonial, in which case, whether it's writing a fake or false testimonial. I'd have to think about whether it would violate 465.2A. It might. I don't have the rule in front of me. And
So that's something that I think we see the most in our industry. It's somebody who puts up a website and says, these are the top 10 casinos in Las Vegas. And they have, a relationship where they're making money off of some of them, but they haven't actually visited all of them. So So I guess kind of the bottom line is either way, you can't do that. It's either in violation of the act or it's in violation of the rule, depending upon how it's done. Either way, it's not okay, but which one it falls under, which then kind of dictates the type of action that you take and the penalties and all of that.
One should not make false claims in promotion. And yes, if one does, it probably violates the FTC Act if one's making false claims. And I'd have to go back and look at the rule with it in front of me before I answer the question about someone, whether it's a deceptive testimonial in violation of Section 465.2A. I don't have it in front of me.
Now this is kind of a long one that's getting back to testimonials for your own company. So if I make a video testimonial for my company, everything I say is factual. Do I need to disclose my employment if I'm making that video for my company?
What does that mean?
So it says I currently make videos for our brand where we turn them into ads or social posts. I'm never lying about the experience or facts. I'm never pretending to be a customer, but I'm not always disclosing my employment status for that company.
If someone is saying that they if somebody's talking about their experience with a product or a service or a business, they're giving a testimonial for it. And if they're giving a testimonial for their business, and it's not otherwise clear to people watching the testimonial that they're an employee, then, or an owner, or otherwise an insider, then it needs to be disclosed. It would be a violation. It could be otherwise clear to people seeing the testimonial from a context, but without knowing more, I would say that they would need to make a disclosure. I mean, there's some very well-known business people out there in the world. If Bill Gates gave a testimonial for Windows, I don't know that he needs to make a disclosure saying that he owns the company or used to own the company.
Got it. So this next question I just popped in, it goes to that buying fake influence. How will this impact influencers who purchase followers or bots on Instagram? I've seen examples of what appears to be bots commenting similar things like, I love this product. I've had so many benefits using this. So if they're on Instagram, if they're on TikTok, whatever, and they're buying followers, then
that's a violation.
That's a violation. And even if they're is there any distinction between if they're buying real people to make those comments or if it's a bot that they're purchasing?
Yes, for it to be I'm sorry. For it to be a violation, it needs to be a bot or a hijacked account. If someone simply says, "I'll give you $5 to tell everybody how much you love my post," or if you love my post, I'll enter you into a raffle. That's not a bot. It's not a fake account, and it's not covered by this provision of this rule. Could it still be deceptive? It could still be deceptive, but it's not a violation of the rule.
Okay. Real quick, Gayla, were there any of the other pre-scheduled questions that you were not able to get in yet?
No, I think we got answers for everything that I had for myself.
Awesome. Well, as we are coming down to the last minute and a half here, I want to thank you both. I want to thank Gayla and IntegraShield for sponsoring us today and helping me put all of this together, the outreach to Michael and everything. And Michael, obviously, most especially, we are so glad that you came today. This stuff is still rolling in on LinkedIn, so clearly there's a lot of discussion still to be had here. So best for people who want to follow. I know, like for me, I have the FTC and my RSS feeder, so anything new that comes out, I'm kind of watching it. For somebody who's not as big a geek as I am, but they want to know just where they can look these kind of things up. Is it just going to ftc.gov? Or are there other specific places that people should be looking for this stuff?
Well, the reviews portion of our website, which is www.ftc.gov/reviews, has lots of information about reviews, testimonials, our cases, our rule, etc. And I've showed that slide before. One can go there, Hopefully our updated business guidance, which will be a Q&A format, will be available in the coming weeks. It is also possible to send an email to endorsements@ftc.gov, endorsements@ftc.gov, and we do try to answer questions.
And we at the PMA will definitely be on the lookout for that new guidance. And as soon as we see it come out, we'll make sure that we get that out to all of our members and to the entire performance marketing industry. So thank you both so much. Thanks everyone for coming into LinkedIn today.
Thanks,
This has
Trisha.
been fabulous. Thank you.
All right. Bye.
Bye.